Good day to Dr. and everyone. We are Kumpulan Gemilang will present about the question 2 of assignment 2. These are group members of Kumpulan Gemilang. For the introduction, we as intern has received a memo from Madam Lai regarding clients' legal matters which related to the incorporation of a company, effects of incorporation, and laws relating to company institution, which require us to give legal advice to the matters in accordance with the Company Act 2016.
Good morning, I'm Chaichi with paper number 272694. The first question is, Bank Mega Berhad is going to change its name to Bank Mega Jaya Berhad. A registered company may undergo the change of name as a result of major transformation, including changes in management and shareholder structure, rebranding, change of business activities, and etc. This can also happen when the management thinks that the name is too generic and unmemorable. The key issue of this case is, can Bank Mega Berhad change its name to Bank Mega Jaya Berhad? We refer to the Companies Act 2016, which is also known as Act 777. We refer to Section 227, Subsection 1 and 4, which is the company should apply to the registrar to confirm the availability of the new name and apply for a reservation of the name. We also refer to the Section 28, which lists out the regulations and requirements of the change of the name of the company. A company may resolve that its name may be changed by special resolution, and the company should notify the registrar of the change of its name within 30 days from the special resolution was passed. These are stated in the Subsection 1 and 2. Subsection 3 states that the registrar will register the new name of the company and issue a notice of registration of the new name upon the compliance with the provisions of this Act and payment of the prescribed fee. Subsection 4 states that the change of name will take effect from the date the notice of registration of new name has been issued. Subsection 5 and 6 state that the change of name of the company shall not affect the rights or obligations of the company and any legal proceedings brought by or against it. In this case, Bank Mega Berhad must submit the proposed name, which is Bank Mega Jaya Berhad, to the Companies Commission of Malaysia (SSM) to confirm the availability and make a reservation of the new name. Then Bank Mega Berhad should make sure that the change of the new name will not affect the rights or obligation of the company and any legal proceedings brought by or against it. Then Bank Mega Berhad must pass a special resolution to conclude the approval of the change of company name and notify SSM within 30 days once the SSM had approved it. Then the new name will be registered and a notice of registration of the new name will be issued by SSM upon compliance with the procedures and payment of the application costs. Bank Mega Berhad will change to Bank Mega Jaya Berhad from the date the notice of registration of the new name has been issued. In conclusion, Bank Mega Berhad can change its name to Bank Mega Jaya Berhad once it follows all the requirements and regulations listed in the Companies Act 2016. That's all from me. I'll pass the floor to my colleagues.
Next question is, Fumat Berhad refused to repay the loan to creditor A, as A is also a substantial shareholder in FMB. Now we look at the introduction. A substantial shareholder is defined as one who has an interest or interests in the voting shares in the corporations that is not less than 5% of the total voting shares in the corporations. The issue for this question is, will Fumat Berhad FMB be able to refuse to repay the loan to creditor A? By referring to the Section 20 of the Company Act 2016, a company is a separate legal entity and it shall have a legal personality separate from that of its members. And Section 136, Subsection 2 of the Company Act 2016 provides that when a person owns a substantial shareholding in a firm, then he or she is a substantial shareholder of that firm. For this question, we can refer to this case. Mr. Salomon was a sole proprietor of a shoemaking business. He then transferred his business to a company called Salomon & Co. Ltd. The transfer price was paid to Salomon by a form of debenture. When the company faced liquidations, Salomon had priority to make a claim. As a result, the unsecured creditors were unable to receive any. The House of Lords held that as long as a company was duly and properly incorporated, it should be treated as a separate legal entity. This ruling therefore means that Mr. Solomon was not personally liable to pay the debts of the company, and also established the corporate will between the company and its owner or shareholders. In this case, A that contributes to the capital of the company through loans is known as a creditor, and she is also a substantial shareholder of Fuma Berhad when she owns a substantial holding of the company. Since the company has a legal personality separate and independent from the identity of its shareholders, hence any rights, obligations, or liability of a company are distinct from those of its shareholders. Thus, the company is liable for the repayment of the loan to creditor A, although creditor A is a substantial shareholder of that firm. So the conclusion is, notwithstanding creditor A is a substantial shareholder in Fumat Berhad F&B, is required to repay the loan to creditor A.
The third question is, a newly incorporated company B does not want to have a company constitution. Now, move to the introduction of this question. A company constitution is a legal document that lists out the company objects and powers, as well as governs the company internal affairs and administrations. The issue is whether the newly incorporated company B does not want to have a company constitution. According to Section 31, Subsection 3 of the Company Act 2016, if a company has no constitution, the company, each director, and each member of the company shall have the rights, powers, duties, and obligations as set out in the Act. If the company B does not want to have a company constitution, then the Act will govern its internal management. Specifically, the whole provision of the Company Act 2016 will apply to the Company B and serve as the default constitution. Move to the conclusion of these questions. Under the Company Act 2016, there is no compulsory requirement for a company to have a constitution. However, Company B is still encouraged to adopt a constitution as part of good governance.
As conclusion, changes of the name of company is allowed but subject to availability. Second, an entity need to pay any amount due to any entity as the company is treated as separate entity. Number 3, it's okay if the company chooses to not have own constitution. However, we suggest that the company should have own constitution to enhance good corporate governance in company. That's all from us. Thanks for watching.